state your name.
Gilbert Schaffnit.
And what do you do, Gilbert?
I'm a criminal defense attorney. I practice in Gainesville, Florida. Well, my practice includes all types of offenses, white-collar offenses, and also sex crimes in the federal system and in the state system, child pornography offenses, travel to meet a minor offense, and regular contact offenses. And that's pretty much a concentration of my practice right now.
Okay, and you've just spoken at the RSOL National Conference, and you talked about child pornography issues. Can you tell me what attracted you to getting involved in that area of law?
Well, I had a client that I represented in 1993 who happened to be gay, and he was just turned 21 years old, and he was involved with a young man who was 17, almost 18. Back then they did not have Romeo-Juliet legislation. I was able to get him a reasonably good disposition. He was a student at the University of Florida. They had had sexual relations voluntarily, but in Florida it was considered statutory rape because of the age of the young man at the time. Now Florida has since changed its laws, but at the time it was as an offense. He later committed another violation of supervision, and upon his release from the North Carolina Department of Corrections, he applied for work at my law office as a legal clerk, and he ended up being with me for 10 years. And during that time, I saw a lot of people being subjected to what I considered to be unnecessary restrictions as part of sex offender probation. And I lived actually the experience myself because, of course, I had a registered citizen as an employee of my business, and you know, his probation officer would stop by, and so I experienced kind of firsthand what he was going through, and it got me interested in the field. And so a lot of my clients now are registered citizens who are petitioning to have their cases revisited, petitioning to have conditions of supervised release in the federal system or probation in the state system modified to allow for them to live their lives. And so I'm a strong believer in redemption and the ability of an individual to change. And it's my feeling that, particularly with respect to the registry, it is a lifetime of restriction, and it has, you know, relegated many folks to menial jobs that they are only able to get because their employers are willing to take chances with them. But it's killed a lot of careers. It's deprived the community of the talents of a lot of people that have a lot to offer, who are no longer a threat to society, but unfortunately, because of the lifetime registration, many of these individuals simply can't find productive work. I have yet to represent a person charged with possession of child pornography that scored outside of the first zone of criminal history. That is, they have no prior record. The overwhelming majority are married with children. Again, no prior record. They have productive employment. I have represented sportscasters. I've represented lawyers. I've represented physicians. I've represented engineers. I've represented politicians. They come from all walks of life. And again, they are individuals who are productive members of society, who have good paying jobs, who have loving families. And so the prototypical image of the dirty old man or the person who is a threat to commit a hands-on offense, I don't see that in my practice. The overwhelming majority of prosecutions in my district are of individuals that are not involved in production and in no way involved in committing hands-on offenses involving minors.
Okay, good. So you touched on it lightly there, but could you maybe expound a little bit on what kind of effect these crimes have and the sentencing, particularly in the aftermath, have on families and children of offenders? Because I suppose most people would think, well, the offender got what they deserve, but what kind of backlash does that have for the family unit as a whole?
Well, that's a very good question, and it's something that many times people don't realize and understand. If you are married to a registered citizen, if you are a loved one of a person who is on sex offender probation, in many respects you are on sex offender probation, and you are branded and tarnished with the same brush, as it were. The ability of probation officers to do searches of residences, to make unannounced visits to residences, to monitor daily comings and goings. For instance, in Florida, registered citizens are not permitted to engage in Halloween activities. They're not allowed to be, in many instances, around children at all, unsupervised. And so I represent a lot of folks who, once they're sentenced, maybe some other attorney has represented them, and they're being released from prison on probation, and lo and behold, one of the conditions of their release is that they not have contact with minors, including their own biological children. And so, if you can imagine the effect that it has on the spouse, the mother, who's waited for their loved one to be released from prison, only to be told that the order of probation prohibits even contact with their own biological children. And so in many instances there is a mechanism by which the judge can modify that particular provision, but it is fair to say that anyone who loves or has any contact with a registered citizen is subjected to the same search and seizure problems that the citizen themselves has to suffer from, the unannounced visits, the restrictions on internet activity, the restrictions on where you live, where you visit, your vacations. I mean, every aspect of an offender's life, if they're on sex offender probation, if they're on any kind of supervision under the federal system, is subject to monitoring, and in many instances, in order to do the simplest things as a family, you have to get a federal court order or a state court order to allow what would normally be considered an everyday thing. So it's a significant impact on anyone who is associated with anyone that's affected by these laws. When I was growing up, I was told that I shouldn't smoke marijuana because marijuana would lead me to do heroin or to do harder drugs. And I just assumed that that was true. And in many instances, that comment was based upon interviewing the heroin addict who said, yeah, I used to smoke pot. There is no causal link between people that smoke marijuana and people that end up doing heroin, but the fear factor drives people in that direction, and it's the same with child pornography. The studies indicate that there are massive numbers of people who view child pornography who do not have an interest in any way in harming a child or sexually battering a child. And the studies are out there, and in many instances part of my job is to educate the court that there is no such linkage, and that the recidivism rates for sex offenders generally cannot be applied to child pornography offenses. You need to look at each individual recidivist rate in isolation. For instance, something that you might think is counterintuitive, but the lowest recidivism rate for sex offenders often is in the area of incest offenses, whereas the highest rates of recidivism offenses involving hands-on with children involve adult males who are sexually attracted to prepubescent and pubescent boys. And so, it requires that you look at the studies, the peer-reviewed journals, to determine what, in fact, the recidivism rates are. In many instances, they are in low single digits. In rare instances, they are higher, but certainly If you look at the worst of the worst in terms of sex offenders, you can find other types of crimes, other types of conduct that have as high or if not higher recidivism rates. We don't treat those people differently. We don't treat serial burglars in the same manner that we treat serial sex offenders. You could be living next door to someone who's committed a series of armed robberies, a series of burglaries, a series of rapes or robberies, and not know anything about them because, of course, the focus is on sex offenses with respect to registration and notification. And so, a lot of it is just an educational process. People need to be aware. And for purposes of notification, what a probation officer that I'm friends with has told me is what he tells people when he goes to inform them of a registered person being in their neighborhood is you don't have to worry about that person because you know who he is, you know he's on sex offender probation, you know where he lives, and I've just told you what his crime involved. There are many people living around you that are equally or more dangerous that are not on any kind of registry that you probably should be more afraid of, but unfortunately the law does not stigmatize them to the degree that it does the sex offender. And so, the probation officer, I think, has the right approach. People are far more safe in many instances with people that have been committed for child pornography offenses than they are people that have been committed for violent offenses, but the law doesn't treat registration of those offenders and notification of those crimes in the same manner. Well, to use the marijuana analogy that I just used, when people who are tempted to use marijuana are told lies that will do in their life, told that it will cause them to hallucinate, they're told that it will lead them to heroin, they tend to lose respect for the people that are telling them that. And I think, unfortunately, that's where our laws are now with sex offenses. Because the agenda is politically motivated, and because people that are involved in politics know that if they sponsor a bill that's tough on sex offenses, it's something they can use to get themselves elected or reelected. The area is rife with generalities and oversimplifications, and the effect of that can be dangerous. It causes the public to lose respect for the system when the person who is viewing small numbers of images of child pornography is lumped in and treated the same as a pedophile. And just the term pedophile is misunderstood by most lay people because they don't understand what the DSM-5 definition of a pedophile is, and they just consider anybody that is involved in any way with anything related to sexual encounters with a minor as a pedophile. And so we need to step back and look at risk. Well, basically the studies have shown that risk assessment needs to be done based upon the nature of the person's sexual interest and the nature of their offense. The AWA, the Adam Walsh Act, attempted to place crimes and categories of offenders into tiers, and in theory that's a good thing. In Florida, where I practice, we discriminate between offenders and predators, but unfortunately there needs to be more discrimination and more categorization and more separation between people that pose minimal risk and those that pose great risk, because again, it makes people in the general public less safe if they're told that everybody poses the same high risk, when in fact the studies would indicate that they don't. We need to make sure that we are protected from the people that we need to be protected from, and for the others that pose minimal or low risk, we need to make sure that those individuals get the services that they need to continue to pose little or no risk, and we need to make sure that we do not ostracize them and turn them into non-productive citizens.
So why aren't we doing it? I mean, how do you assess that, and why aren't we doing it?
I think the reason we're not doing it is because it's easier to do what we're doing. It's easier to paint with a broad brush. It's less expensive, And if we treat everybody the same, then we don't have to worry about making difficult choices. But the reality is that there are significant degrees of risk that individuals pose. There's a broad spectrum of risk, and the restrictions on individuals need to be proportional to the risk that those individuals pose to the general public.
Okay, so you're talking about more of an evidence-based sentencing or an evidence-based penalty?
Well, not only do we need to create laws that make those distinctions, I mean, we do in other cases. I mean, for instance, if you are intoxicated and you're homeless and you break into a house for purposes of avoiding the cold on a winter's day, you have no intent to do anything inside the house, the law in Florida would say that you've trespassed as opposed to committed a burglary. A burglary requires a specific intent to, say, break into the house to steal something or to harm someone. And so we've discriminated between, it's the same act, it's going into the house, but it's with different intent. And so one's a misdemeanor, one's a felony. If you break into a house with the intent to harm somebody and you carry a firearm, you know, it can be an even higher degree of offense. We do that somewhat with sex offenses. For instance, in Florida, if you are a person in familial or custodial authority over an individual, you get an enhancement. If you are a person that uses a drug or alcohol to incapacitate your victim, there's an enhancement for that. But just in terms of looking at the individual's conduct, again, there needs to be more separation, both in terms of how they're charged, ultimately how they're sentenced, and more importantly, the degree to which you can normalize their lives and reintegrate them back into the mainstream of society without putting them in a position where you relegate everyone to being a groundskeeper where you have a business in your wife's name because you're afraid to put your own name on your business for fear that no one will, you know, take advantage of your services because your name appears on a registry.
Okay, great. And finally, what kind of warnings would you give to parents or even to children themselves about how soon or how readily they would be subject to some kind of prosecution for what they might consider relatively minor acts?
Sure. Well, you know, young people these days have a different notion of privacy and the importance of privacy than individuals my age. I notice, you know, my younger friends post things about their lives on a daily basis on Facebook and other social media that I'm alarmed that they share with other people. Most of their interactions with their girlfriends and their boyfriends, the taking of selfies, the taking of lurid or candid shots of genitalia that then get posted and then get distributed, commit, you know, that those are crimes. They're crimes at the state court level, they're crimes at the federal court level. You know, people need to be educated, and young people particularly need to be educated that they need to be very cautious of what they're doing in that arena, because the laws, again, are written in order to paint a broad brush over that conduct. Same with respect to downloading software, particularly peer-to-peer file sharing software, which is free and available off the internet. FrostWire, LimeWire, Shiraza, BitTorrent, all of those programs. Just about everyone that downloads those free downloads does not click or does not check the terms of use. They don't read it. Even lawyers don't read it. They click that they accept the terms of use, and those terms of use include the fact that you are willingly and knowingly, whether you realize it or not, agreeing to share files. And so if and when an image of a child pornography situation arrives on your computer, and you know, you would download it, you can be subjected to prosecution whether you intended to acquire it or not, because you have agreed based on the terms of use to file share. And so people need to be very cautious about that activity. They need to be very cautious about visiting adult sites because those sites are full of ransomware and malware and spyware generally, but they're also situations where they can distribute things that are a crime at the federal and state level. So young people need to be a little bit more cautious when they engage in that kind of activity.
Anything else you'd like to share?
No, I'm here at the RSOL conference to talk about what I do and talk about the type of practice that I have, and specifically about federal sentencing guidelines in child pornography cases. People need to be educated and be aware that at the federal level particularly there is zero tolerance for possessing or downloading or sharing child pornography, and the sentences are very draconian and in many instances exceed the term of commitment that one can receive for committing violent and in some cases acts of terror. And so individuals need to be aware that those laws are out there, they exist, and that sometimes good people end up getting in bad situations. Most of my clients, as I said, are people that have good jobs, they have good marriages, they're first offenders. These are not individuals that are anyway recidivists or people that pose a risk to society, and those individuals need to be treated based on the risk that they pose, and that's part of what I do, is to try to educate the court that this is an individual that you can in fact put on probation and they will serve out their term of probation. They do not need to be branded for life. They do not need to have their marriages and their lives ruined over this situation.
All right, thank you.
Welcome.